Hello, Assalamualaikum. My name is Mohammad Rushdan bin Ahmad Rosli. Today, I would like to present air pollution from industrial odor pollution caused by rice huts. Law of private license of on occupational safety, health, and environmental management in Malaysia. Chronology of cases. Industrial odor pollution caused by rice huts. Case 1. Pacific Engineering versus Haji Ahmad Rice Mill 1966 2 MLJ 142. The plaintiffs were in the business of selling heavy earth-moving equipment and construction equipment such as heavy tractors and forklift trucks. Products hard from the defendant's mills will fly to the plaintiff's premise, and their workers had to cover their mouths and nose to prevent themselves from inhaling the dust. Their machine displays were easily covered by dust from paddy huts, and their lubrication oil was dirty by the dust from the paddy huts. The court held public nuisance could only be instituted with prior consent of the Attorney General in the absence of special damage. A public nuisance, however, may be instituted without consent of the Attorney General if the plaintiff has suffered special damage. Here, the plaintiff had proven that they suffered personal discomfort and injury property. An injunction was granted against the defendants, and they were not allowed to burn rice huts in the compound of their premise. To succeed in action for public nuisance, the plaintiff must prove that he or she suffered special or extra damage over and above the members of the community. The damage must be direct consequence in and is substantial. Example of direct damage: P suffer breathing problem due to the smoke pollution. Type of offence and indicators. Action under the law of private nuisance on occupational safety, health and environmental management in Malaysia. Decision on pollution of the atmosphere. No person shall, unless nuisance emit or discharge any waste into the atmosphere in contravention of the acceptable condition specified under 21, Section 21. Second is without limiting generality. The subsection 1, a person shall be deemed to emit or discharge waste into the atmosphere if the A, B, C, D terms is applied. Third is any person who contravenes subsection 1 shall be guilty of the offence that shall be liable to a fine not exceeding 10,000 ringgit or imprisonment for a period not exceeding 2 years or to both, and to a further fine not exceeding 1,000 ringgit a day for every day that the offence is continued to after a notice by the Director General requiring him to kiss the act specific therein have been served upon him. Court decision. In the case of Pacific Engineering versus Haji Ahmad Rice Mill, the plaintiff had proved that they suffered personal discomfort and injury to property, thereby satisfying the requirement special damage. An injunction preventing the defendant from burning rice huts in the compound of their premise was granted. The court held that in the action for public nuisance, a plaintiff might institute proceeding without obtaining prior consent from the e.g., if he suffered special damage. In conclusion, air pollution should not occur with the open burning as it will adversely affect the surrounding community and pollution. Furthermore, with the global warming worsening, air pollution should be controlled by the authorities.
Hi, Assalamualaikum. I'm Mohammad Nizam bin Abdullah will be presenting about open burning in landfill at Pulau Burung, Nibong Tebal, Pulau Pinang. So here is plaintiff and defendants. For the plaintiff by Jabatan Alam Sekitar, JAS of Pulau Pinang, and for the defendants by founder companies which is PLB Terang Sendirian Berhad or those involved with open burning. Here for chronology of cases, for the phase 1, Jabatan Alam Sekitar JAS of Pulau Pinang has spotted multiple open burning operation. For the phase 2, the state of Jabatan Alam Sekitar Pulau Pinang has already taken action against the landfill manager which is PLB Terang Sendirian Berhad, issuing 40 notification and 2 compounds for open burning violation. For the phase 3, there have been judicial cases involving the management of leakage. It will considered at the end of the month as a suspension. For the phase 4, more than 4 hectares of the 60 hectare Pulau Burung dam were devastated by fire on Wednesday evening, according to the reports. For the phase 5, residents of adjacent Ladang Biram and Kampung Kebun Baru were harmed by the landfill air pollution, resulting in the evacuation of roughly 400 people from the 2 settlements. For the phase 6, furthermore, more than 10 schools within a 10-kilometer radius of the west have been forced to close for 3 days. And lastly, for the phase 7, according to the Majlis Keselamatan Negara, the Pulau Burung landfill has been declared as a level 1 disaster area. Here for the types of offence and indicator, offence of open burning are punishable under Section 29A of the Penal Codes. And then checking landfill compliance with the environmental impact assessment, which is EIA standard under Section 34A of the Environmental Quality Act EQA 1974. For the court's decision, penalties on the offender more than 2,000 ringgit Malaysia in fine and judicial action with a maximum punishment of 500,000 ringgit Malaysia and a possible sentence of 5 years in jail. For the conclusion, most of the air pollution problems are caused by companies and people activities. It is essential that the government enforce much higher compound rates for offenders involved in pollution cases in the country. Residents of Pulau Pinang are urged to refrain from open burning in order to preserve the quality of the air. If air pollution does not capture the attention of a large number of people, the future generation will undoubtedly lack the value of environmental. Thank you from me.
Okay, Assalamualaikum. My name is Mohammad Khairi bin Junoh and I will present about marine pollution case due to ship sinking in the coast of South Mumbai, India. Plaintiff versus defendant. Plaintiff. Who is plaintiff? Plaintiff is for this case is Samir Mehta. He is an environmentalist, and for this case, the defendant is involving Union of India. the ship owner and other party involved. About chronology of the case study, it starts on August 12, 2011. A ship carrier sailing from Indonesia to the Hajj with more than 60,054 metric tons of coal, 290 tons of fuel oil, and 50 tons of diesel sank around 20 nautical miles off the coast of South Mumbai, resulting in marine pollution. Second, Mr. Samir Mehta filed a petition with the National Green Tribunal with Section 40 and 15 of the National Green Tribunal Act of 2010 were used to file the petitions, and the third is taking into account the arguments of the petitioner and arguments of the respondent. While guided by the Maritime Zones Act 1976, the judge then awarded compensation to the defendant. There are three types of offences indicated. First is dumping of cargo onto a ship, such as coal into the sea. Second is fuel oil that had been stored on board was released, resulting in an oil leak. And third one is the materials were found in the wreckage of the ship. The ship employed in the conveyance in this instance is unseaworthy, and the respondent should never have used it for transportation. As a result, the sinking of the ship is considered similar to dumping in the situation. As a result, the tribunal has eventually awarded compensation to the data group in the amount of 100 crores and Adani Enterprise in the amount of 5 crores, both of which would be paid to the Ministry of Shipping under the Government of India. In a nutshell, the National Green Tribunal stressed the need of protecting the marine environment from damage caused by oil spills, wrecks, and other hazards in this landmark decision. The tribunal took the initiative in emphasizing the need of environmental protection and made the polluter pay for inflicted environmental damage. The decision boosted humanity's aspiration for a clean environment. In this way, the tribunal plays a vital role in instilling correct environmental awareness.